Please be seated. The sitting is open. The court meets today and will meet in the next 3 weeks to hear the oral argument of the parties on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, 11 states intervening. I note initially that Judge Okowa has recused herself from the case under Article 17, Paragraph 2 and Article 24, Paragraph 1 of the Statute of the Court, and that Judge Bandari is unable to participate in these proceedings for personal reasons. I also note that for reasons duly made known to me, Judge Shue is unable to take her seat on the bench today and for some time in the coming days. Since the court does not include upon the bench a judge of the nationality of either of the parties, both parties have availed themselves of the right under Article 31, Paragraph 3 of the statute to choose a judge ad hoc. The Gambia chose Ms. Davenida Mpile and Myanmar Mr. Klaus Kress. They were duly installed as judges ad hoc on the 10th of December 2019 during the phase of the present case that was devoted to the request for the indication of provisional measures submitted by the Gambia. I shall now recall the principal steps of the procedure in the present case. On the 11th of November 2019, the Gambia filed in the registry of the court an application instituting proceedings against Myanmar concerning alleged violations of the Convention on the Prevention and Punishment of the Crime of Genocide, adopted by the General Assembly of the United Nations on the 9th of December 1948, to which I shall refer as the Genocide Convention or the Convention. In its application, the Gambia sought to base the jurisdiction of the court on Article 9 of the Genocide Convention in conjunction with Article 36, Paragraph 1 of the Statute of the Court. The application contained a request for the indication of provisional measures by an order dated the 23rd of January 2020. Having heard the parties, the court indicated certain provisional measures addressed to Myanmar. Time limits were subsequently fixed and then extended for the first round of written pleadings. The Gambia filed its memorial on the 23rd of October 2020. Myanmar, for its part, on the 20th of January 2021, raised certain preliminary objections to the jurisdiction of the court and the admissibility of the application. By a judgment of the 22nd of July 2022, the court found that it had jurisdiction on the basis of Article 9 of the Genocide Convention to entertain the application filed by the Gambia, and that the said application was admissible. Myanmar filed its counter-memorial on the 24th of August 2023 within the new time limit set for that purpose. By an order of the 16th of October 2023, the court authorized the submission of a reply by the Gambia and the rejoinder by Myanmar. The Gambia filed its reply on the 23rd of May 2024, and Myanmar filed its rejoinder on the 30th of December 2024. After the closure of the written proceedings, both parties requested authorization to submit new documents pursuant to Article 56, Paragraph 1 of the Rules of Court. On the 8th of September 2025, Myanmar sought the admission of 3 new documents. Taking into account the lack of objection by the Gambia, these documents were added to the case file. For its part, the Gambia presented several requests to submit new documents. The court authorized the production of some of these documents, which were added to the case file. Pursuant to Article 56, Paragraph 3 of the Rules of Court, Myanmar commented in writing on the new documents admitted and submitted documents in support of its comments. I shall now say a few words about the proceedings related to the declarations of intervention in the case. On the 15th of November 2023, the Maldives filed a declaration of intervention in the case, with reference to Article 63 of the Statute of the Court. On the same date, a joint declaration of intervention was filed, pursuant to the same provision, by Canada, the Kingdom of Denmark, the French Republic, the Federal Republic of Germany, the Kingdom of the Netherlands, and the United Kingdom of Great Britain and Northern Ireland, to which I shall refer as the joint declarants. By an order of the 3rd of July 2024, the Court decided that the declarations of intervention submitted by Maldives and the joint declarants were admissible, insofar as they concern the construction of the provisions of the Genocide Convention. On the 28th of February and the 3rd of March 2025, the Maldives and the joint declarants, respectively, filed written observations on the subject matter of their interventions pursuant to Article 86, Part 1 of the Rules of Court. Declarations of intervention under Article 63 of the Statute of the Court were also filed by Slovenia on the 29th of November 2024, the Democratic Republic of Congo, to which I shall refer as the DRC, on the 10th of December 2024, Belgium on the 12th of December 2024, and Ireland on the 20th of December 2024. By an order of the 25th of July 2025, the Court decided that the declarations of intervention submitted by Slovenia, the DRC, Belgium, and Ireland were admissible, insofar as they concern the construction of provisions of the Genocide Convention. The DRC, Slovenia, Belgium, and Ireland filed written observations on the subject matter of their intervention under Article 86, Part 1 of the Rules of Court on the 22nd, 23rd, the 24th, and the 25th of September 2025, respectively. By letters dated the 17th and the 21st of October 2025, the parties and the intervening states were informed that the Court considered that it had been sufficiently informed of the position of the intervening states on the subject matter of the intervention by way of written observations, and that it did not deem it necessary for them to submit observations in the course of the oral proceedings in accordance with Article 86, Paragraph 2 of the Rules of Court. I shall now address the organization of the oral proceedings, in particular with respect to the presentation of the evidence. By letters dated the 17th of July 2025, the registrar informed the parties of the date fixed by the court for the opening of the hearings on the merit of the case and asked them to provide by the 8th of September 2025 the names of any witnesses and experts they intended to call during the oral proceedings, as well as other information required by Article 57 of the Rules of Court. The parties communicated to the registry within the time limit fixed information concerning the witnesses and experts that they intended to call at the hearings. The Gambia indicated that it wished to call witnesses and an expert, whereas Myanmar stated that it intended to call only witnesses. By letters dated the 17th of October 2025, the registrar informed the parties of decision taken by the court in relation to the hearing of the witnesses and expert during the oral proceedings. The parties were in particular informed that the court had decided that the parties' witnesses and expert to be called by the Gambia would be heard in the order requested by each party. The parties were required to submit by the 18th of November 2025 a written affidavit for each of the individuals they intended to call as a witness at the hearings. The Gambia was also required to submit a written statement by the expert it intended to call to testify. The parties were also requested to provide, by the same deadline of the 18th of November 2025, unredacted copies of any previous statements or accounts given by the witnesses or expert called to testify during the oral proceedings, which have been annexed to their pleadings in redacted form. The letters underscored that the unredacted version of the affidavits, written statement of the expert, and prior statements or accounts provided by each party would be communicated to the judges and the other party, but would be treated as confidential and would not be made public, available to the public. By letters dated the 13th of November 2025, the Deputy Registrar informed the parties of further decisions taken by the court concerning the procedure for examining the witnesses and the expert called by them. The parties were thus advised that after making the solemn declaration provided for in Article 64A of the Rules of Court, each witness would be asked to confirm his or her written affidavit, and if applicable, any prior written statements or accounts annexed to the written pleadings, subject to any correction the witness may wish to make. The calling party would then proceed to its direct examination, which would take the form of replies by the relevant witness to questions put to him or her by counsel. This would be followed by cross-examination of the witness by the other party, which would be confined in scope to written and oral statements already made as part of the witness evidence in chief. A re-examination by the calling party would then be possible, limited to matters having arisen as part of the cross-examination. The expert called by the Gambia would be asked, after making the appropriate declaration in accordance with Article 64B of the Rules of Court, to endorse his written statement as well as his earlier reports annexed to the Gambia's written pleadings, subject to any correction the expert may wish to make. The written statement and reports would constitute the expert's evidence-in-chief and serve in lieu of his direct examination at the hearings. This would be followed by cross-examination of the expert by Myanmar, which would be confined in scope to statements already made by him as part of his written statement or reports, and re-examination by the Gambia, which would in turn be confined to matters arising as part of the cross-examination. Following re-examination, questions could be put to the relevant witness or expert by the President on behalf of the court or by individual judges. The witnesses and expert would respond orally and without delay to any question put by the parties or by the judges, except in particular circumstances, for example, when specific information was requested that needed to be verified. In order to ensure the safety of the witnesses called by the parties, the court decided that they would be heard in closed sessions, with only judges, registry staff, interpreters, technical personnel, and members of the delegation on the official list provided by each party to the court being allowed in the courtroom during the in-camera sessions. The parties were also informed that the court had agreed to the use of pseudonyms when addressing the witnesses called by the parties or when referring to them at the hearings. By a letter dated the 18th of November 2025, the Gambia provided written affidavits of its witnesses as well as the written statement of its expert. By a letter of the same day, Myanmar informed the court that it intended to call only one witness and reserved the right to call a different witness if for any reason the former should be unavailable to testify. Myanmar also provided confidential written affidavits for both of these witnesses in the Myanmar language, accompanied by certified translations into English. It further indicated the pseudonyms that should be used for these two witnesses. After ascertaining the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the pleadings and documents annexed in their redacted versions as appropriate will be made accessible to the public on the opening of the oral proceedings, except for certain annexes that would be kept confidential. In addition, with regard to written pleadings and documents annexed, which contain written statements and accounts given by the witness called by the parties, as well as the redacted version of the affidavit of witnesses and the verbatim record of their testimonies, it was decided that these materials would only be posted on the court website after the end of the oral proceedings. The court also decided to make accessible to the public, on the opening of the oral proceedings, the reports submitted by Myanmar on the measures taken pursuant to subparagraph 4 of the operative clause of the Order on Provisional Measures of the 23rd of January 2020, and the Gambia's comments on them. In this respect, the court notes that the parties were consulted on this matter and did not object to such publication. Further, after consulting the parties and the intervening states, the court decided to make accessible to the public, on the opening of the oral proceedings, the written observations of the parties on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene, and those of the parties on the admissibility of the Declaration of Intervention in accordance with Article 84, Paragraph 2 of the Rules of Court, as well as the written observations of the intervening states referred to in Article 86, Paragraph 1 of the Rules of Court on the subject matter of their intervention. I note the presence in the court of the agents and counsel of the two parties. In accordance with the arrangement for the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round will begin today with the oral pleadings of the Gambia and will close on Tuesday, the 20th of January 2026, following Myanmar's first round of pleadings. For the first round, each party will have 6 sessions of 3 hours at its disposal. The second round of oral argument will begin on Monday, the 26th of January, and conclude on Thursday, the 29th of January. Each party will have 3 sessions of 3 hours to present its reply. In addition, the court will hear witnesses and experts between the 2 rounds of oral argument. The witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. In this first setting, the Gambia may, if required, avail itself of a short extension of time in view of the time taken up by my introductory words. I now give the floor to the agent of the Gambia, High Excellency Mr. Dawda Jallow. Sir, you have the floor.
Mr. President, esteemed judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. 6 years ago, the Gambia filed its application with this court, seeking to hold Myanmar accountable for its violations of the Genocide Convention. In January 2020, you ordered provisional measures and did so unanimously. We are now finally in the merits hearing, after which the court will decide whether Myanmar is responsible for acts of genocide against the Rohingya group, as alleged by the Gambia. As you will hear over the next 3 weeks, and in particular over the next 4 days, in deciding to bring this case, the Gambia acted on the basis of most careful reflection and assessment of the facts. We did not bring this case lightly. We brought this case after reviewing credible reports of the most brutal and vicious violations imaginable inflicted upon a vulnerable group that had been dehumanized and persecuted for many years. We received and carefully examined the meticulous reports of the United Nations fact-finding mission, dispatched by the UN Human Rights Council. We also examined reports issued by the reputable international human rights organizations, which sounded the alarm on the genocide of the Rohingya unfolding in northern Rakhine State. Those credible reports from diverse and independent sources left no doubt in our minds that Myanmar had to be held accountable for its violations of the Genocide Convention. And so we acted. Genocide Convention is the first multilateral human rights treaty that has been adopted. but its words will be meaningless unless they are acted upon and enforced. It is up to the state parties to the Genocide Convention to invoke affirmatively its provisions in order to truly liberate mankind from the odious scourge that is the crime of genocide. That is why the Gambia invoked Article 9 of the Convention and brought its dispute with Myanmar to this honorable court. The Gambia stands tall in the international community of states and takes pride in promoting and protecting human rights, including international accountability for genocide and other atrocity crimes. We do this out of sense of responsibility, grounded in the history of which we too suffered under a military junta. Over 2 decades of brutal dictatorship have taught us that we must use our moral voice in condemnation of oppression, of crimes against individuals and of groups, wherever and whenever they occur. It is also taught to us that accountability is imperative. Otherwise, impunity will ensure that such crimes are repeated over and over. In present times, these issues are more important than ever. And the court's role is more important than ever as a bastion for the rule of law. Sadly, Myanmar appears to be trapped in a cycle of atrocities and impunities. Nobody has been held responsible for the crimes against the Rohingya. Indeed, the military that perpetrated the genocide actually felt emboldened to overthrow the civilian authorities again. Myanmar's original agent in this case, the former state councillor, Madam Aung San Suu Kyi, has been imprisoned by the military junta, deprived of her liberty since she was swept from power by the same generals who continued to rule the country. And Senior General Min Aung, who commanded the military during the genocide, now rules over Myanmar as the leader of the junta. Predictably, violence and atrocities have spread throughout the country, affecting Myanmar nationals of all ethnic groups. Mr. President, while Gambia is the only applicant state, we are not alone in this cause for justice and accountability. Indeed, as the General Assembly stated in 1946, genocide shocks the conscience of mankind and results in great losses to humanity. And this is because humanity, our shared humanity, is made of various groups protected under the Convention. This is why we stand before you with full backing and support of 57 member organizations of Islamic cooperation. We also stand in solidarity with 11 intervening states from across the world who have urged the court to interpret the Convention in a meaningful way in the manner advanced by the Gambia. We stand too with the support of dozens of international human rights organizations and defenders whose investigations and reports have corroborated the findings of the UN fact-finding mission and its successor, the International Investigative Mechanism for Myanmar. And most importantly, we stand together with and for the Rohingya survivors of Myanmar genocide. This group of Myanmar nationals have endured decades of appalling persecution and years of dehumanizing propaganda. This culminated in the savage genocidal clearance operations of 2016 and 2017, which were followed by continued genocidal policies meant to erase their existence in Myanmar. We are proud that, once again, Gambia's delegation includes several members of the Rohingya community, including those who have traveled from the refugee camps in Bangladesh to be with us at this hearing. I invite them to stand so their presence may be acknowledged. Thank you. I turn to the case. It is not about esoteric issues of international law. It is about real people, real stories, and real group of human beings, the Rohingya of Myanmar. They have been targeted for destruction. They are farmers, laborers, teachers, mothers, fathers, sons, daughters, grandparents. They are ordinary folk. They have dreams and aspirations like all of us. And first and foremost, it is the most simple dream to be able to live in peace in their homeland under conditions of dignity and security. Myanmar has denied them that dream. In fact, it turned their lives into a nightmare, subjecting them to the most horrific violence and destruction one could imagine. 3 of the Gambia's witnesses, who will testify in closed sessions next week, have to endure that nightmare personally. They are first-hand eyewitnesses to the clearance operations that took place in 3 of the villages that were focused on by the UN fact-finding mission, namely Minji, also known as Tulatoli, Chutpin, and Muanu, also known as Monapara. All 3 of them lost family members in genocide. For their safety, we will only refer to their initials when we reference their written and oral testimony in these oral proceedings. Mr. President, members of the court, the Gambia has carefully examined jurisprudence and has fit this court's jurisprudence and has fit its case within that legal framework. There were genocide acts and there was genocidal intent. During the clearance operations in 2016 and 2017 and subsequently. This is evident based on particular circumstances in many villages and Myanmar's overall pattern of conduct. The Gambia believes that the evidence that has been submitted to you and which you will hear described this week admits of only one reasonable inference in regards to that pattern of conduct, that Myanmar acted with intention to destroy the Rohingya as a group or in whole or in part. The Gambia is proud to be represented by a diverse and talented team of international advocates who will present all aspects of the Gambia's case. 5 of them, including 2 Gambian state attorneys from my chambers, will be pleading before this court for the first time. After me, Professor Philip Sands will introduce the legal context for this dispute. He will be followed by Paul Reigler, who will provide an overview of the Gambia's case in the context of the court's previous 2 genocide cases, and that is Bosnia, Serbia, and Croatia, Serbia. Mr. Aslan Suleiman will then provide an overview of the relevant geography, demography, and history of the Rakhine State and discuss why the Rohingya are a protected group under the convention. In the afternoon, Mr. Reigler will return. In the afternoon, Mr. Reigler will return to discuss the quality and reliability of Gambia's evidence in this case. Then Mrs. Tafagwa Pasipanodia will present the history of discriminatory laws and persecution of the Rohingya in Myanmar, which is one of the indicators of Myanmar's genocidal intent. Mr. Suleiman will return to discuss another of such indicators, Myanmar's year-long efforts to disseminate anti-Rohingya hate propaganda. On Tuesday afternoon, Mr. Andrew Lowenstein will provide an overview of Myanmar's anti-Rohingya clearance operations and discuss how their organized nature and execution constitute another indicator of Myanmar's genocidal intent. Our presentations will continue with 4 speakers who will provide detailed presentation on the clearance operations in specific locations. Ms. Pasipanodia will discuss Myanmar's genocidal attack in Minchi or Tulatoli. Ms. Jem Hong Ho will present on Myanmar's genocidal attacks in Chut Pien. Ms. Mariam Angom will examine Myanmar's genocidal operations in Muang Nu or Monu Port Para. And Mr. Charles Kombenjai will describe Myanmar's genocidal attacks in other notable villages. On Wednesday morning, Ms. Ho will discuss how the extreme brutality of Myanmar's clearance operations evidence Myanmar's genocidal intent. Ms. Pasiponodia will then focus on why the pervasive sexual violence during Myanmar's clearance operations indicates its genocidal intent. She will be followed by Mr. Lowenstein, who will demonstrate that Myanmar's targeting of children is also an indicator of its genocidal intent. After that, Ms. Yasmin Alamin will demonstrate that Myanmar's destruction of evidence is also an indicator of its genocidal intent. And Professor Per Dazin will conclude the morning session with a presentation on Myanmar's pervasive impunity and how that also reveals its genocidal intent. On Wednesday afternoon, Mr. Suleiman will show that Myanmar's argument that its clearance operations were ARSA counterterrorism operations is not a defense to genocide because the evidence fully established that the manner in which these operations were organized and executed contradicts every tenet of counterterrorism doctrine, including Myanmar's own. Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers demonstrates Myanmar's commission of the atrocities of genocide under Article 2 of the Convention. He will be followed by Professor Sands, who will highlight proof that Myanmar acted with the requisite mens rea or dolus specialis of genocide, and that's its intent to destroy the Rohingya as a group, in whole or in part, is a manifestly reasonable inference to be drawn from that proof. Ms. Reichler will conclude our presentation on Wednesday by showing that genocidal intent is the only reasonable inference that can be drawn from Myanmar's pattern of conduct across the clearance operations, and specifically that the evidence demonstrates that it would be entirely unreasonable to infer that the intent of Myanmar's targeting, mass killing, maiming, raping of many thousands of unarmed and defenseless Rohingya civilians, including pregnant women, children, the elderly, and the infirm, as well as burning of their houses and razing of their villages, was to combat terrorism. On Thursday, in our final session, Ms. Jessica Jones will discuss other breaches of convention for which Myanmar is legally responsible. Mr. Suleiman will examine Myanmar's breaches of the court's provisional measures order of January 2020. Then Professor Dezan will present the remedies requested by the Gambia. And finally, Professor Sands will conclude our opening presentations on Myanmar's Commission of Genocide, on the witnesses you will hear, and on the significance of this case. The Gambia will present one additional witness, Professor Michael Newton, who will testify in open session next week. Professor Newton is a former military officer who specializes in the laws of war and counterterrorism operations. His testimony will demonstrate that Myanmar's clearance operations cannot be reasonably explained by the intention to counter terrorism. Rather, the only reasonable inference that can be drawn from its conduct is an intention to destroy the Rohingya group as such. Mr. President, honorable judges, these oral hearings come at a time in which the fundamental principles of international law, as enshrined in the UN Charter, are under stress and threat globally. Many have lost faith in the promise of international law. And many are looking at this case to see if the Genocide Convention is more than just words on paper. We are confident that this court, the principal judicial organ of the United Nations, will stand in the breach and uphold the rule of law, which epitomizes our collective conscience. As the guardian of our moral and legal compass under the Genocide Convention, we come to you because this court is the only hope for justice and accountability that the Rohingya and all people of Myanmar so greatly deserve. Mr. President, members of the court, I thank you for your courtesy and for your keen attention to this case and for allowing me to address you. With your permission, I would ask that you call Professor Sands to the stand. Thank you.
I thank His Excellency Mr. Daud Jallow. I now invite Professor Philip Sands to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honour to appear before you on behalf of the Gambia in respect of this application under the 1948 Genocide Convention. The importance of this case in relation to the protection of the Rohingya community in Myanmar and more broadly, and the importance of the issues before you at a time when the international rule of law is under grave threat are plain. This morning, I'm going to address the beating heart of this case, the meaning and effect of the Genocide Convention. How the court approaches this will determine how the Gambia's application is decided. And as you well know, the Convention is of singular importance in the history of modern international law. Adopted in 1948, very largely as a result of the efforts of one man, Raphael Lemkin, it was the first modern human rights treaty to be adopted after the horrors of the Second World War. It is emblematic. It is emblematic of who we are, of who we wish to be, of how truth and law are to address matters of raw power. If the Convention is diminished, then we are diminished, and the values that were articulated in that extraordinary post-war moment are diminished. The protections provided by the 1948 Convention have been addressed by this court on several occasions. These previous judgments inform how it is to be applied in the case of the Rohingya, and my colleagues and I will draw on these sources, guided by the rulings of this court, as well as judgments in genocide cases before other international tribunals and increasingly before national courts, in respect of the points that I make in this submission. Mr. President, it's to be emphasized from the outset that there are many aspects of the legal framework which are not in dispute between the parties. Myanmar and the Gambia agree on certain aspects and what the Convention says about them, but there are important areas of disagreement. And in respect of these areas of disagreement, the Gambia and all 11 of the intervening states speak with one voice on how the Convention is to be understood consistent with the history, the context, the object and purpose of the Convention as this court has interpreted and applied it. That united interpretation is, we say, important, for it highlights that where Myanmar's interpretation diverges, as it often does, it is a solitary expression of dissent. I'm going to proceed this morning as follows. First, I'm going to address the context and negotiating history of the Genocide Convention. Second, I'm going to identify key aspects of subsequent practice under the Convention, which elucidates the approach we invite the Court to take. Third, I'm going to set out the significant points of agreement between the parties and the interveners on key provisions of the Convention. Fourth, I'm going to address the key components of genocide, namely the relevant actus reus and mens rea. And fifth, and finally, I'm going to address other aspects of the legal framework to be addressed by my colleagues in due course over the next 4 days. Start with the context, the negotiation of the Convention. Mr. President, Raphael Lemkin invented the word genocide. He constructed that word out of the Latin and Greek words genus and side, to mean the killing of a group or of a people. And here you can see the word in his own writing on the screen, a document that may be found in the Rare Book and Manuscript Library at Columbia University in New York City. He chose the word genocide as the title for Chapter 9 of his book, Axis Rule, which was published in November 1944. I've taken the liberty of bringing a copy of the first edition of that book, my own copy, to court today. As you'll see, it is personally inscribed by Raphael Lemkin in the Nuremberg courtroom on the 4th of July 1946. This room today is in direct connection with courtroom 600 and the Palace of Justice. And I invite you, please, to read all of Chapter 9 of that book. It's not long. It's available online. As you read Lemkin's words, I suspect, like me, you may be struck by two things. First, the convergence of Lemkin's account of the indicators of genocide that he found in the 1930s and the 1940s with the evidence that is before you in this case. And second, that the approach taken by Raphael Lemkin is fully consistent with the approach taken by this court in its jurisprudence. As you will know, despite the crime being argued before them, the judges at Nuremberg failed to mention the word genocide at all in the 1946 judgment. And this is what prompted Raphael Lemkin to engage in efforts elsewhere, leading up to the first ever session of the United Nations General Assembly, and ultimately his efforts bore fruit in December 1948. You, the judges of this court, need no reminder of the horrors which preceded and precipitated the formulation and adoption of the Genocide Convention, and which led states parties, including so many of the countries which you are each from, to heed Lemkin's exhortation to bring an end to the odious scourge of genocide. It was an imperative task in 1948, as the crime of genocide took its place alongside war crimes and crimes against humanity. And to be clear, while international law treats these crimes as distinct, it does not establish a hierarchy among them. Sadly, the task of 1948 remains as imperative today as it did then. There's one aspect of the negotiating process to which I wish to draw the Court's attention. Myanmar suggests that its crimes against the Rohingya, and they are crimes, cannot be characterized as genocide. Why? Because simply too few Rohingya were subjected to abusive acts. The argument is fallacious, as we will show in the coming days. But in this respect, the negotiation process of the Convention is important, as with Raphael Lemkin's intentions, because it makes clear that the crime of genocide is not a numbers game. The negotiating process involved 3 drafts, and in reaching agreement on the 3rd and final draft, there the negotiators addressed the scale of destruction necessary to constitute the crime of genocide. The negotiating committee recognized that the Convention should include as instances of genocide such crimes as group massacres or individual executions on the grounds of race, nationality, or religion. France's delegate promoted this position, allowing that even a single death could constitute genocide. That is the approach enshrined in the Convention's wording, that there must be an intent to destroy the group in whole or in part. Of course, in this case, terribly, there is not just a single death. There are thousands of deaths and tens and hundreds of thousands of other genocidal acts, with upwards of 1 million human beings today in Cox's Bazar. Pause for a moment and reflect on that number. Over 1 million people. But let us not forget that the words "in part" were explained by Mr. Rafat, who served on Egypt's delegation, as being intended to achieve the aim of the French amendment. I turn to subsequent practice. This Court's first interpretation of the Genocide Convention came not long after its adoption, the famous 1951 advisory opinion. And there the Court recognized and underscored the Convention's purpose, a purely humanitarian and civilizing purpose. The high ideals which inspired the Convention, the Court said, provide, by virtue of the common will of the parties, the foundation and measure of all its provisions. And so it is today. That purpose and those ideals inform the way in which the Court interprets and applies the provisions of the Conventions in this case. The Court's jurisprudence on the Convention, in particular with the Bosnia and Croatia judgments of 2007 and 2015 respectively, is the lodestar on which the Gambia's application has been based. Other aids to interpretation, including the jurisprudence of the international criminal tribunals and national courts, and it is worth mentioning that in particular it is the courts of Germany that have in recent years played the leading role in relation to rulings, judgments of genocide perpetrated in northern Iraq and Syria, including against the Yazidi population, as well as the findings of international commissions which provide guidance on issues arising under the Convention, as the interveners have made clear. But it is the Court's own jurisprudence, your jurisprudence, that has played a central role in guiding the Gambia's approach, and we've fully relied on that jurisprudence in the decision of the Gambia to bring the case and in arguing the case in our written pleadings and in the course of these oral hearings. That approach of the Court informs the views of all the interveners and the Gambia in these proceedings. And both parties and all the interveners agree on the basic and foundational principle articulated with force by the Court in the Bosnia judgment, that a state is prohibited from committing genocide and a state may be held internationally responsible for the crime of genocide. And we note and agree with the Democratic Republic of Congo's very helpful summary of certain additional significant points of agreement. The DRC's submissions include the following. First, that a situation of armed conflict does not preclude the crime of genocide. Second, the Convention does not require that a genocidal intent be the sole motive pursued by a respondent state or its agents, but it permits of multiple and overlapping motives. Third, a genocidal intent does not have to be expressly stated and may be established or inferred either from particular circumstances or a pattern of behaviour or conduct. And fourth, the requirement that a substantial part of the protected group is targeted does not refer to a purely quantitative criterion, but is to be interpreted in the light of quantitative, qualitative, and geographic factors. These are very important points of consensus on the basis of which we say the court can proceed. I turn now to the definition of genocide, the famous Article 2 of the 1948 Convention. This provides as follows. In the present Convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. The 5 acts that follow in the text of Article 2 are A. Killing, B. Causing serious bodily or mental harm, C. Deliberately inflicting conditions of life calculated to bring about the group's physical destruction in whole or in part, D. Imposing measures intended to prevent births, and E. Forcibly transferring children to another group. Any one of these acts committed with the requisite intent is sufficient to constitute the act and the crime of genocide. And my colleagues will take you to evidence over the course of this week which will show many acts falling within the first 4 categories of Article 2 having been committed by Myanmar against the Rohingya group. In the counter-memorial, Myanmar argues that the number of victims is relevant to the determination of whether the actus reus of genocide has been committed. This is wrong. It makes this argument specifically in relation to the actus reus of killing under Article 2A, and Myanmar invites the court to conclude that unless killings are, and I quote, part of a campaign committed on a scale that is capable of bringing about the physical destruction of the relevant group or part of the group, they will be inadequate to constitute the actus reus of the crime of deliberate destruction of a human group. You can read that at paragraph 4.61 of the counter-memorial. Pure invention. There is no basis in the text of the Convention or the jurisprudence of the Court, or as I've already explained, in the negotiating history of the Convention to support this erroneous claim in respect of the actus reus under Article 2A. To the extent that numbers may ever be relevant, it's a factor that goes not to actus reus, but potentially to the question of whether the mens rea of genocide has been made out. This is because it may, but not necessarily, it may bear on whether there is a reasonable inference that acts were carried out with the specific intent to destroy the group. That aspect of establishing the existence of the mens rea of genocide is a point to which I will return on Wednesday, to be followed by Mr. Reichler. But to be clear, there is no numeric or substantiality threshold inherent in the actus reus. As this court has observed, and the chapeau of Article 2 makes plain, there are, and I quote, 2 constituent elements, end of quote, to genocide, the mens rea and the actus reus. And whilst both must coexist for genocide to have been committed, they are, and I quote your words, analytically distinct, end of quote. The issue of numbers or the existence of concerted plans plays no part in establishing actus reus. And I also wish to underscore that killings under Article 2A are only one of 5 possible genocidal acts, 4 of which have plainly been established in the evidence that is before you. The Gambia does not contend that acts within the scope of Article 2E, that's to say forcibly transferring children out of the group, took place. But acts in all 4 other categories of Article 2 have been committed. And as the 6 joint interveners have underscored, and I quote, "There is no hierarchy among the underlying acts of genocide, and the legal relevance of all acts targeting a protected group must be emphasized." End of quote. Thus, although terrible killings undoubtedly have occurred in this appalling case, it has to be underscored that the other modalities of the actus reus are just as central to the Gambia's case as acts of killing. Prominent in this case are acts falling within the scope of Article 2, paragraph B, causing serious bodily or mental harm to members of the group. The kinds of acts falling with this category are sadly diverse in this case. They include acts of sexual and gender-based violence, acts causing physical and psychological harm, and acts of forced displacement. And you're going to hear a lot more from this from the witnesses next week. I make 2 particular points in this regard. First, Myanmar's campaign against the Rohingya is appallingly characterized by widespread sexual and gender-based violence. As the joint interveners have submitted, and as the Gambia has also affirmed, the harm caused by such acts is by its very nature and effects almost universally serious. This has been recognized by this court in the Bosnia judgment, which endorsed the vital findings of the Rwanda tribunal in the Akayesu case. And that case made clear that the effect of rape and sexual violence are one of the worst ways of inflicting harm on the victim as he or she suffers both bodily and mental harm. End of quote. These are genocidal acts. They fall within the scope of Article 2, paragraph B, all the more so where, as in the present case, children are involved, a point that is made with force by the interveners. They may also constitute actus reus under Article 2C and 2D. Very frankly, the evidence you're going to hear about this week is dreadful, and it's going to be very tough to listen to some of it. But listen to it we all must, and draw the necessary conclusions from it. We say you must. Second, forced displacement, the permanent expulsion of a people from their homeland, is plainly capable of causing serious mental harm to members of the group, alongside any physical harm suffered in the course of their expulsion or which contributed to their fleeing their homes. In this case, it affects not only hundreds of thousands and upwards of 1 million human beings, but it's recognized, expulsion is recognized by the ICTY as capable of being a genocidal act. And let's be clear, expulsions do not have to result from the formal removal of people by bureaucratic state processes or the use of Auschwitz-style cattle cars. Expulsion arises in this case after the ransacking of villages, the burning of houses, the constant threat of violence against all who remain. It is these acts that contribute to the forced displacement that forms the actus reus within Article 2, paragraph B. And as the International Residual Mechanism for Criminal Tribunals has made clear, forced displacements do not always require physical force. They can, and I quote, be met through the threat of force or coercion, such as that caused by fear of violence, duress, detention, psychological oppression, or abuse of power, or taking advantage of a coercive environment. It is the absence of genuine choice that makes the displacement unlawful." End of quote. And this is exactly what has happened in the present case, along with the use of physical force, causing grave harms to the Rohingya within the meaning of Article 2, paragraph B. Such displacements may also be genocidal actus reus within the terms of Article 2C, as the court recognised in the Bosnia case. This point has also been widely recognised by international criminal tribunals in genocide cases. For example, in the Ptolemyer case, the Yugoslav tribunal held that underlying acts of genocide may include, and I quote, "methods of destruction that do not immediately kill members of the group, but ultimately seek their physical destruction by systematically expelling members of the group from their homes." End of quote. I turn now to the second constituent element of genocide, namely the mens rea. This is a subject that has received a lot of attention, and not just from lawyers. Writers, journalists, psychiatrists, psychoanalysts, psychologists have all turned their mind to the key point, the question of intent. Now, I note, before turning to the dolus specialis of genocide, that each of the underlying acts, actus reus acts, have their own mens rea, which must be present in the perpetrator when the act is done. As this court explained in the Bosnia judgment, and I quote, "Killing must be intentional, as must causing serious bodily or mental harm. Mental elements are made explicit in paragraphs C and D of Article 2 by the words deliberately and intended, quite apart from the implication of the words inflicting and imposing. The acts, in the words of the International Law Commission, are by their very nature conscious, intentional, or volitional acts." End of quote. And so, for the actus reus to be present, the relevant acts must have been committed with the requisite volitional mindset. In most cases, it's going to be straightforward to establish that an act is intentional, as we say it is in this case. But, alongside this aspect, and as an essential ingredient in genocide, is the existence of what has been called a dolus specialis. The intent must be to destroy in whole or in part a national, ethnical, racial or religious group, and to do so as such. Now let's turn first to the first part of this totemic chapeau, the fundamental basis of genocide, the core feature of the crime, what distinguishes it from other crimes, is that it is predicated on establishing an intention to destroy. The intention, however it is expressed, must be to achieve the physical or biological destruction of the group in whole or in part. Although the extent to which such destruction is in fact achieved is not relevant to the establishment of the dolus specialis. The victim of a genocide must be part of a recognizable and definable group, joined by a common nationality or ethnicity or race or religion. The intent must be to destroy the group as such. That requirement was explained by this court in the Bosnia judgment, some of you will know very well, as underscoring that genocide requires an intent to destroy people who share a particular group identity because of who those people are, as the court said. The words as such emphasize that intent to destroy the protected group. In this regard, they are targeted not because of what they have actually done or might do, but simply because of who they are. That is what counts in genocide. And let's be clear, there's not a shred of doubt, none, that the Rohingya are a group within the meaning of the Convention, and there is not a shred of doubt that they have been and that they continue to be to this day targeted as such. My colleague, Mr. Suleiman, is going to address the point later today. Alongside these requirements, the chapeau to Article 2 stipulates that the intent has to be to destroy the group in whole or in part. As the court's findings in respect of Srebrenica make plain, a targeted part of a group has to be a substantial part. But that does not mean that it has to be a numerically significant part in the context of the group overall, where other factors combine to make it substantial. As the court stated at paragraph 296 of the Bosnia judgment, substantiality is to be assessed by reference to three elements, namely quantitative factors, relevant geographic factors, and emblematic or qualitative factors. The evidence you're going to hear over the course of this week and next will leave no doubt that the targeted part of the Rohingya group was by reference to these three elements, and it was substantial. I turn next to the need to establish the presence of the dolus specialis. As the court has made clear, this can be either on the basis of direct or indirect and circumstantial evidence. In the Croatia judgment 10 years ago, the court clarified its approach to identifying the existence of dolus specialis. It said, and I quote, "In the absence of a state plan expressing the intent to commit genocide, it is necessary in the court's view to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2. In its 2007 judgment, the court held that, and you'll see the words here on the screen, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent." End of quote. Now, those are words, no doubt, we're going to be coming back to. The court can proceed on the basis of overt, that is to say, written incriminating evidence of a general plan. But for understandable reasons, perpetrators have tended to avoid that approach. And so the court, very wisely, we say, has recognised, has affirmed, that it can proceed by reference to circumstantial evidence in two distinct situations. First, by reference to particular circumstances which are convincingly demonstrated, or second, by reference to a pattern of conduct which could only point to the existence of the special intent. In the context of this application, as the evidence on the court's record establishes and as will be addressed by my colleagues this week, there are particular circumstances which convincingly show that Myanmar and its state organs acted with genocidal intent against the Rohingya. And that is especially clear in the case of at least three individual villages: Minji, Chut Pien, and Mang Nu, the harrowing accounts of which will be presented to the court tomorrow morning. Just as in Srebrenica, in the Bosnia case, the particular circumstances of what happened in those three villages, the concerted violence and devastation, the disproportionate and utterly inhuman treatment of the Rohingya who lived there, the widespread sexual violence, and even the targeting of Rohingya children, present, we say, the inescapable conclusion that the crimes against the Rohingya who lived there were perpetrated with genocidal intent. To be clear, we say that those 3 villages also formed part of a pattern, a wider pattern of conduct, which extended to dozens of other locations in northern Rakhine state, and from which genocidal intent is the only inference that could reasonably be drawn from the acts in question. That does not mean, however, as I've already submitted, that in relation to a pattern of conduct, it has to be the only motive. What it means is that on the basis of the evidence before you as to that special intent, it would be unreasonable to conclude that an intent to destroy the group in whole or in part did not exist. And in this case, that test is plainly met. The pattern of conduct across the various locations identified in northern Rakhine is only explicable, we say, on a reasonable basis by the existence of a genocidal intent acted upon by Myanmar. When the court considers, as it must, all of the evidence taken together, the only reasonable conclusion to reach is that a genocidal intent permeated and informed Myanmar's myriad of state-led actions against the Rohingya. Now, we note that Myanmar, in its rejoinder, accepts and agrees that genocidal intent can operate alongside and simultaneous with other motives. The interveners also agree with that. Indeed, the court has itself recognised that certain acts performed without genocidal intent may nevertheless also assist in deducing the existence of a genocidal intent. For example, in the Croatia judgment, the court held that acts, and I quote, acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention and may be significant as indicative of the presence of a special intent inspiring those acts. End of quote. This makes it clear in our submission that both such intentions, ethnic cleansing and genocide, and maybe other crimes, may coexist. And in this regard, I refer you to the intervention of the Republic of Ireland and to Judge Bandari's helpful separate opinion in the Croatia case to explain the point. What this means is that for a pattern of conduct to point only to the existence of genocidal intent is not to say that it could point to such intent only. This is how Ireland has put it, and Ireland is, of course, a land of remarkable writers, thinking of James Joyce and Seamus Heaney and Colm Tóibín and Fintan O'Toole, writers who really know about the power of words. And their lawyers have done the same thing. This is how they put it. The human mind can, of course, accommodate and act upon more than one intention. And the same conduct can be intended to achieve 2 or more results, however attainable each may be. It follows that it is perfectly possible that a pattern of conduct upon examination could point to 2 separate intentions, only one of which is genocidal. This possibility was recognised by Judge Bandari in his separate opinion in the Croatia case, wherein warning against conflating punitive motive with genocidal intent, he noted that genocidal intent may exist simultaneously with other ulterior motives. This approach, which recognises and takes account of the realities and complexities of human behaviour, we might call it the human factor, and in particular its darkest acts of expression through violence and conflict, is messy and it's complex. But this approach has got to be the right one in the real world if the Convention is to have any practical utility or function. It is this precisely that informed Lemkin's approach, as you will see when you read chapter 9 of his book. He understood, writing in 1944, that the perpetrator's mind is often a concoction of messy, mixed, overlapping motives. And accommodating that human reality is a way in which the particular threshold imposed by the dolus specialis must reflect the actuality of how human beings are and why they act, individually and collectively through the state. What makes them, what makes us do terrible things to other people. While the Gambia recognises that it's the attributed attention of Myanmar that matters in this case, and not that of each individual perpetrator on the ground that has to be established, it also cannot be overlooked that a state acts through people. The court, in seeking to determine whether genocidal intent is the only reasonable inference to be drawn from a pattern of conduct, is not, therefore, asked to determine whether genocidal intent existed in isolation or exclusively or only. Rather, it is required to ask itself whether the evidence before it as to circumstances and conduct are such that, irrespective of the existence of any other motive or motives that may have been identified or stated, and which will no doubt be present in most real-world cases, a genocidal intent also must have been present. Myanmar's assertion that in the conduct of the clearance operations targeting Rohingya villages, it was merely undertaking counter-terrorism operations, cannot, therefore, serve of itself to rebut the existence of a genocidal intent. It is perfectly possible for there to have been a counter-terror motive behind some of Myanmar's actions, but at the same time, in the course of those operations, a genocidal intent also existed and prevailed, and in some form propelled the actions that were taken. Indeed, as Judge Cansade Trindade recognized in the Croatia case, and I quote, "Genocide may be a means for achieving military objectives just as readily as military conflict may be a means for instigating a genocidal plan." End of quote. In establishing whether genocidal intent must have been present in the context of a pattern of conduct, the court helpfully indicated in the Croatia judgment some of the most important indicators of that intent. And I'll mention four. They are, first, and I quote, "the scale and allegedly systematic nature of the attack," end of quote. Second, the fact that those attacks are said to have caused casualties and damage far in excess of what was justified by military necessity, end of quote. Third, quote, "the specific targeting of members of the protected group," end of quote. And fourth, quote, "the nature, extent and degree of the injuries caused to the protected population," end of quote. In this case, the UN fact-finding mission, an independent body, has a key role, and its findings, we say, are authoritative. It has identified 7 indicators of genocidal intent, not in abstracto, but in the vast amount of evidence it has gathered in respect of Myanmar's actions towards the Rohingya. And they strongly correlate with the factors the court identified that I've just mentioned in the Croatia judgment in relation to patterns of conduct. So the UN FFM, entrusted with functions by the United Nations, concluded that genocidal intent to destroy a Rohingya people as such could be inferred in the following way. First, the Tatmadaws' extreme brutality in its attacks on the Rohingya. Second, the organized nature of the Tatmadaws' destruction. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operations. Fourth, the insulting, derogatory, racist, and exclusionary utterances of Myanmar officials and others prior, during and after the clearance operations. Fifth, the existence of discriminatory plans and policies. Sixth, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. And seventh, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law, both as they were occurring and after they occurred. In due course, my colleagues are going to take you through a close consideration of these 7 indicators which emerge from the vast amount of evidence before you. And the Gambia invites this court to reach exactly the same conclusions that the FFM did, namely that the only reasonable conclusion is that Myanmar acted in this case with genocidal intent. Of course, the Commission of Genocide is not the only internationally wrongful act prohibited by the Convention. Article 1 also creates an obligation to prevent and to punish genocide, and Article 3 prohibits a range of acts ancillary to genocide, including, but not limited to, conspiracy and direct and public incitement to commit genocide. Whilst the Gambia's primary case is that Myanmar has committed genocide in violation of Article 1 of the Convention, violations of Articles 3 and of the duties to prevent and punish genocide also form part of our case in full. And these other punishable acts will be addressed by my colleague, Ms. Jones, later in the week. Before I conclude, a brief word about the evidence before the court in this case, and you're going to hear more about this, and the approach that we invite the court to take. The court itself has set out its task in general terms, in other cases plainly. It is the duty of the court, after having given careful consideration to all the evidence in the record, to assess its probative value, to determine which facts must be considered relevant, and to draw conclusions from them as appropriate. The court will make its own determinations of the facts on the basis of the totality of the evidence presented to it, and it will then apply the relevant rules of international law to those facts which it has found to be established. And so it's for the court to consider whether in totality the evidence before you, in the case brought by the Gambia, stands up. There's no single type of evidence or method of proof that the court restricts parties to rely on. Evidence from any source can be taken into account, and it will be for the court to assess its credibility, reliability, and probative value to the issues in question. It is for the party alleging a fact to demonstrate its existence. But even this, in the court's practice, is not an absolute rule. As the court has said, the determination of the burden of proof is in reality dependent on the subject matter and the nature of the dispute brought before the court. It varies according to the type of facts which is necessary to establish for the purposes of the decision of the case. So the court takes an inherently, and we say appropriately, flexible approach to the evidence it is prepared to receive and consider in order to ensure that it is equipped with the materials necessary to make its own determination of the facts and to apply to those facts the relevant rules of international law. Mr. Reichler is going to address this in detail. The Gambia's evidence, its reliability and its probative value will be a matter for him. Suffice it to say at this early stage, the totality, the body of evidence presented by the Gambia on this application, fully underpinned, as it is, by the careful, thorough investigations of the UN FFM and the many eyewitness accounts that were collected by that body, is compelling and persuasive. To take the words of the court, it is convincing. It provides a strong foundation for the court to reach conclusions on the facts and to find that the Rohingya genocide is clearly established. Mr. Mr. President, members of the Court, I've addressed the existing legal standards for proving genocide under the 1948 Convention in general terms, including proof of dolus specialis. These standards build directly on the approach set forth by Raphael Lemkin in his book, Axis Rule. And so I'm going to conclude by returning to where I began. New conceptions require new terms, Lemkin wrote in November 1944. He noted in these pages the evolution of international law having brought about a considerable interest in national groups, as distinguished from states and individuals. He invented the concept of genocide to deal with that evolution. And by genocide, he wrote, we mean the destruction of a nation or of an ethnic group. This occurred, he continued, as a composite of different acts of persecution or destruction. And on his interpretation, they occurred in two phases. One, these are his words, destruction of the national pattern of the oppressed group. The other, the imposition of the national pattern of the oppressor. And he continued, the oppressed who were the subject of genocidal acts could remain or they could be removed. The oppressed were always members of certain national groups who lived as minorities. And I quote him, if these groups should not be adequately protected, such lack of protection would result in international disturbances, especially in the form of disorganized emigration of the persecuted who would look for refuge elsewhere. End of quote. And against this background of what he saw between 1933 and 1945, he proposed, quote, an international multilateral treaty should provide for the introduction of provisions protecting minority groups from oppression because of their nationhood, religion, or race. The 1948 Convention is that international multilateral treaty. And Lemkin's words, written in 1944, and Article 2 of the 1948 Convention capture, regrettably but exactly, what has happened to the Rohingya. Lemkin's assessment back in the 1940s was the product of a meticulous exercise of research and reflection. His book and the Convention are testament to the power of ideas, to their reduction into a written and legal form, and to their capacity to hope for the world as a better and safer place. Raphael Lemkin lived through terrible times, just as the Rohingya have. But at no point did he, or his colleague Hirsch Lauterpacht, or so many others like them, choose to curl up in a corner and weep, or conclude that action or international rules were pointless. And the Rohingya have adopted exactly the same approach. And so has the Gambia, whose Attorney General you heard from this morning. That is why the Gambia is here today. Mr. President, the Genocide Convention, including its Article 2, really matter. And so does its meaningful and effective interpretation and application on the facts of this case to the situation regarding the Rohingya. It's to that issue that Mr. Reichler will now turn, and perhaps, after a brief pause, you would call him to the bar. I thank you for your attention.
I thank Professor Sands. Before I give the floor to the next speaker, the court will observe a break of 50 minutes. The hearing is suspended. Please be seated. Please be seated. The sitting is resumed. I now invite Mr. Paul Leichler to address the court. You have the floor, sir.
Mr. President, members of the court,
The sitting
it
is
is,
open.
as always, an honor
The
for
court
me
meets
to
today
appear before
and
you.
will meet in the next 3 weeks
And it is
to hear
a
the oral
special
argument of
privilege
the parties on the
and a
merits
responsibility
in the case concerning
to appear on
application
behalf
of
of
the
the
Convention
Gambia
on
in
the
this
Prevention and
historic case.
Punishment of the Crime of Genocide,
We are very
the
much
Gambia
aware
versus Myanmar,
of its
11
significance
states intervening.
for the parties,
I note
for the
initially
Rohingya people,
that Judge
for
Okowa
all
has
parties
recused
to the
herself from
1948
the case
Convention, including
under
the 11
Article
states
17, paragraph 2,
that have intervened in
and
these
Article
proceedings,
24, paragraph 1
and
of
for
the
the court
statutes of the
itself.
court. And
This
that Judge Bandari
imposes
is
a
unable to
particular
participate in these
obligation
proceedings
on
for
counsel
personal reasons.
to be
I
as
also
careful
note
as
that for
possible
reasons duly made
in
known to
dealing
me,
with the law and the
Judge
facts
Shue is unable to take her seat on the
accurately
bench
and
today
objectively,
and for some time in the
and
coming
to be
days.
as helpful as possible to the
Since
court
the court does not include
in
upon the
your
bench a judge
to
of the
provide the
nationality
right
of
answers
either of the parties,
on the important issues
both parties
that have been raised.
availed themselves
These
of the right
issues
under
include,
Article
among
31,
others,
paragraph 3 of
The
the
legal
statute
standards
to
for
choose
proving
a judge on her.
genocide under the
The
convention
Gambia chose Ms.
and the nature
Davenida
of the
Pillay,
evidence
and
upon which
Myanmar,
the
Mr.
court
Klaus
may
Kress.
confidently
They were
rest its
duly installed
determination
as judges ad
of
hoc
whether
on
those standards
on the
have been
10th
met.
of December
Professor
2019,
Sands has helpfully laid
during
out
the
our
phase of the
understanding
present case
of the
that was
existing
devoted
legal
to
standards
that
for
request for
proving
the indication
genocide,
of provisional measures
including
submitted
proof
by
of dolus
the Gambia.
specialis, as set out
I shall now
and applied
recall
by the court
principal steps
in
of the
its
procedure in the
2007
present case.
judgment in the Bosnia case
On
and
the
the
11th of
2015
November
judgment
2019,
in the Croatia case.
the Gambia filed in the registry
We
of the
understand
court an application
that this is a
instituting
relatively
proceedings
high
against Myanmar
standard of proof,
concerning
and we feel
alleged
that this is
violations of the
appropriate
Convention on the
where
Prevention and
allegations of
Punishment of the Crime of
genocide
Genocide
or other grievous
adopted by the General
international
Assembly of the
crimes
United
are
Nations
concerned.
on the 9th of December
This does not mean
1948,
that the standard set
to
by
which
the
I shall
court
refer as the
has drawn
Genocide Convention
universal
or the
praise.
Convention.
There has been
In
a
its
considerable
application,
amount
the Gambia
of
sought to base
scholarly
the jurisdiction of the
commentary
court
about it.
on
some
Article
of it
9
critical.
of the Genocide Convention
This isn't
in
surprising.
conjunction with Article 31,
A few
36, paragraph
commentators,
1 of the
especially
Statute of the
those
Court.
who have seen the Peace Palace
The application
only in
contained
photographs,
a request for the
think they know
indication
better
of
than
provisional
you do
measures
what the law
by an
should
order
be, and they relish
dated
telling you so.
the 23rd of January
But that is not what the Gambia thinks.
2020.
We
Having heard
respect
the
scholarship,
parties, the court indicated
but we are not
certain
here as
provisional measures
commentators.
addressed to Myanmar.
We are here to present our
Time
case
limits
under
were
the law
subsequently fixed
as your
and then
jurisprudence
extended
has established it.
for the first round of written
We do
pleadings.
not question or
The
challenge.
Gambia filed its
legal
memorial on the
standards
23rd
you
of
have set.
October 2020.
On the contrary, we accept
Myanmar,
them
for its part,
and
on the
argue our
20th
case
of
on the
January
basis of
2021,
those standards
raised
as
certain
defined and applied by the
preliminary
court
objections
in its
to the
prior
jurisdiction of
cases
court
under the
and the
1948
admissibility
Convention.
of the application. By
We
a
have
judgment
no
of
doubt
the 22nd of July
the evidence we
2020
have submitted
2022,
fully
the court
meets
found
those high standards.
that it had jurisdiction
So we have
on the
no need
basis
for,
of Article 9
nor
of the
do we
Genocide
seek
Convention
a
to
change
entertain the
in the
application
approach the
filed
court
by the
has
Gambia,
previously established,
and that the said
including,
application was
but not
admissible.
limited to, the legal standard
Myanmar
for
filed its
proving
counter-memorial
genocidal
on
intent.
the 24th of August
I will
2023
explain why this is
within
so
the
by
new
comparing
time limit
the evidence
set
of
for that
genocidal
purpose.
intent in this case
By an order of
with the evidence
16th
the
of
court
October,
found sufficient
2023,
to establish
the court
genocidal
authorized the
intent
submission
in
of
the
a reply
Bosnia
by the
case,
Gambia
and
the
then by
rejoinder
comparing it
Myanmar.
with the evidence
The
the
Gambia
court
filed
found
its reply
insufficient
on the
in the
23rd of
Croatia
May,
case.
2024,
Our
and
central
Myanmar filed its
submission
rejoinder
is
on
that
the
the evidence
30th
of
of December,
genocide,
2024.
including genocidal intent, in this case
After the closure
is
of the
much
written
stronger
proceedings,
and much
both
more
parties
pervasive
requested
than it was
authorization
in both
to
of
submit new
those
documents
cases.
pursuant to Article
say
56,
That
Paragraph
the
1 of
only
the Rules of Court.
reasonable inference that can be
On the
drawn
8th
from
of
this
September
evidence
2025,
is that there was an
Myanmar
intent
sought the
by
admission,
Myanmar
the
to
admission
destroy
of 3
the
new
Rohingya
documents,
Muslims as a
taking
group
into account
in whole
the lack
or in
of
part.
objection by the Gambia. These documents
My
were
review
added
of the
to
evidence
case
this
file.
morning will necessarily be
For
introductory.
its part, the Gambia
speech
presented
Is
several
intended
requests to
as an
submit new
overview
documents.
of our case.
The court
This
authorized the
afternoon
production
and
of
for
some
the
of
3
these
days that
documents, which
follow,
were added
you will
to the
hear
case file.
a comprehensive
Pursuant to Article
presentation of it
56, Paragraph 3 of the
and
Rules of
how
Court,
it
Myanmar
satisfies the
commented in
standards
writing
set
on the
by
new
the court
documents admitted
for proving
and
both
submitted documents in
the
support
actus
of its
reus
comments.
and the dolus specialis of genocide by
I shall
Myanmar.
now say a few words about the
intention now
proceedings
is to
related to the
provide a
declarations of
roadmap
intervention in the case.
That assists you in fully
On the
appreciating our
15th of
presentation
November 2023,
and in
the
understanding
Maldives
how
filed a
each
declaration
of
of
our speeches, as
intervention
it is
in the
delivered,
case,
builds
with reference to
the
Article
inevitable
63 of the
conclusion
Statute of the Court.
that Myanmar is
On the same
responsible
date,
for the commission
a
of
joint
genocide
declaration of
against the
intervention was
Rohingya
filed
Muslim group.
pursuant to the same provision
With these
by
opening
Canada,
remarks, I
the
turn
Kingdom
to
of
the
Denmark,
Bosnia and
the French
Croatia
Republic,
cases.
the Federal Republic of
As
Germany,
we all know,
the Kingdom
the Bosnia
of the
case is the
Netherlands,
only one
and the United Kingdom of
in
Great
which the
Britain
court
and
found
Northern
that
Ireland,
genocide was committed.
to which I shall refer
The court
as
found it at
as
one
the
specific
joint
location,
declarants.
Srebrenica.
By
The
an
evidence
order
showed that
of the 3rd
Srebrenica
of July
was predominantly
2024,
inhabited
the court
by
decided
Bosnian
that the
Muslims.
declarations of intervention
After it was
submitted
taken
by
over by
Maldives
Bosnian
and
Serb
the joint
forces,
declarants
those
were
forces
admissible.
separated approximately
Insofar as they
7,000
concern the
Muslim men
construction
from the
of the
general
provisions
population,
of the Genocide
removed them
Convention.
to a secluded area, and
On the
murdered.
28th of February
As
and
the
the
court
3rd of
explained,
March
Quoting from
2025,
the
the
ICTY's
Maldives
trial
and the
chamber
joint
in the
declarants
Kristich case, the
respectively
perpetrators, quote,
filed written observations
systematically
on
targeted
the subject matter of their
Bosnian Muslim
interventions
men of
pursuant to
military
Article
age,
86, Part 1 of the
regardless
Rules of Court.
of whether they were civilians or soldiers.
Declarations of intervention
Women, children,
under
and the
Article
elderly
63 of the
were spared
Statute
from
of the
death.
Court were also
They were
filed
forcibly
by
displaced
Slovenia
to other parts
on the
of
29th
Bosnia.
of November 2024.
Citing the appeal chamber in the
Democratic
Kristich
Republic
case,
of Congo,
the court
to
found
which I
that
shall
the
refer
killing of
as the
such a
DRC,
large number of men,
on the 10th of
1/5
December
of the
2024,
overall Srebrenica
Belgium
community,
on the 12th of
quote,
December
would inevitably
2024,
result in the physical
and Ireland
disappearance
on
of the
20th
Bosnian Muslim
of December
population of
2024.
Srebrenica. The court concluded
By
on the basis
by
of these
an order
facts
of the
that the
25th of
actus reus
July
of genocide
2025,
under Article
the court
2A
decided
and B of the
that the
Convention had
declarations of
taken place.
interventions submitted by
court found
Slovenia, the
further
DRC,
that upon
Belgium, and
capturing
Ireland were
Srebrenica
admissible,
and segregating the male
insofar as they
population,
concern the construction
quote,
of provisions
the
of the
Bosnian
Genocide
Serbs
Convention.
devised and implemented a
The
plan
DRC,
to execute
Slovenia,
as many as
Belgium,
possible
and Ireland
of the
filed written
military-aged
observations
Bosnian Muslim
on the subject
men
matter of their
in the
intervention
enclave,
under Article
and that
86,
this
Part
was
1
sufficient
of the Rules of
to
Court
satisfy the
on
dolus
the 22nd,
specialis requirement.
23rd, the
The existence
24th,
of this
and
plan,
the 25th of
which was
September
not spelled out in any
2025,
document,
respectively.
was considered proven by a number
By
of
letters
factors
dated the
identified by the
17th
court.
and the 21st
namely,
of
The
October
number and nature of
2025,
the forces
the
involved,
parties and
the
the intervening
standardized
states
coded
were informed
language used by the units
court
in
considered
communicating
that
information
they had
about the
been sufficiently
killings,
informed
the
of the
scale of the
position of the
executions,
intervening states
and the
on the
commonality
subject matter of the
killing
intervention
methods.
by way of written observations, and that it did not deem it necessary for them to submit observations
Mr. President,
in the course
it is
of the
our
oral
submission
proceedings in
that if
accordance
the
with
court
Article
were to
86,
apply the
paragraph 2
same
of the Rules
legal
of Court.
and evidentiary standards to the present case,
I
it
shall
would
now
have to
address the
conclude,
organization of the oral
as others
proceedings,
have done,
in particular
that Myanmar
with respect to
committed
the
acts of genocide
presentation of the
with
evidence.
genocidal intent against the Rohingya
By
Muslim
letters dated
population
the 17th
during
of July
its so-called
2025,
clearance
the
operation
registrar informed the
in
parties
2016
of the date fixed by
and
the court
2017.
for the
In this
opening of the
case,
hearings on the
unlike
merit of the
Bosnia,
case,
there
and
were
asked them
numerous
to provide
Srebrenicas.
by the 8th
That
of
is,
September
massacres
2025
of large
the names
numbers of Rohingya
any
Muslims
witnesses and experts they intended
destroy
to
the
call
group
during the oral
based on their
proceedings,
identity as such,
as well as other information
carried out by
required by
Myanmar's
Article
armed forces
57 of the Rules
in
of Court.
multiple locations
The parties
across northern
communicated to the
Rakhine State,
registry
where the
within the
vast
time limit
majority
fixed
of the Rohingya
information
Muslims lived.
concerning
In
the
other
witnesses
words,
and
what was
experts that they
proven
intended
to have
call
occurred
at the
at a
hearings.
single site in
The Gambia
Bosnia
indicated
is proven
that it
here
wished to call
to have
witnesses
occurred
and
in
an expert,
scores
whereas
of different
Myanmar stated
Rohingya villages
that it
in Myanmar.
intended to call
Many
only
examples
witnesses.
are given in our written pleadings, some of which
By
will be
letters
discussed
dated
in
the
detail by
17th,
my colleagues. For now,
17th of October
I will call your
2025,
attention to three
the
of these.
registrar informed the parties
The first
of decision taken
is
by the court
Mingyi,
in relation
the
to the
village
hearing
in
of the witnesses
Mongdaw